Good afternoon and welcome to Constitution Day. It's a delight to see so many of you. It's wonderful to see so many of you from the Swarthmore College, but it's also great to see so many of you from the community and surrounding communities. Feel free to come up here and sit. I think that's fine if you'd like to sit on the floor. We have called facilities and they will try to bring in some more chairs as well. Today is, actually tomorrow is the 224th anniversary of the signing of the United States Constitution. It was signed in 1787 on September 17th. Constitution Day or Citizenship Day has been celebrated in this country for many years, but in 2004, the government mandated that all educational institutions receiving any kind of federal aid provide an opportunity to reflect upon the Constitution, to learn the Constitution, and to think about citizenship. I can't think of anyone better for Swarthmore College than to have Jed Rakoff come and help us think about the Constitution and citizenship. And on top of that, to have Carol Nakenhoff introduce Jed Rakoff. Carol is the Richter Professor of Political Science. She teaches constitutional law and was the recent chair of our Environmental Studies program. Carol has recently been writing about the role of organized women in establishing and contributing to the work of this nation's first juvenile court in Chicago, founded in 1899. I give you Carol, who will introduce you to our judge.
Thanks, everybody, for coming out to think about the Constitution. It's easy for me to remember Constitution Day because it's my birthday. So I was aware of it early on, but now that Congress has mandated that we think about it in some kind of systematic way, we are doing what many of our peer institutions do, which is to bring in people who write about the Constitution and or who are judges or members of Congress and so on. And so I'm very pleased to have the Honorable Jed Rakoff with us today. Some institutions today, I noted from the web, we're putting out cupcakes and handing out copies of the Constitution and having a little party, but I think we will have a better time of it. Jed Rakoff is known to many of us at Swarthmore, well known to many of us at Swarthmore. He was an honorary degree recipient here in 2003, and for those of you who are students, Jed was instrumental in setting up the extern program that some of my students have taken great advantage of to help think about what they may want to do upon graduation. Jed is a 1964 honors graduate of Swarthmore College. His major was English literature. And while here, served as president of Student Council, editor of the Phoenix, president of the Debate Club, and more. He went on to receive a B.Phil in history from Oxford, and then graduated cum laude from Harvard Law School. He had a clerkship on the U.S. Court of Appeals, partnerships in several law firms, additional prestigious positions, and was appointed to the federal bench in 1996. So he serves on the federal district court for the Southern District of New York, and that is in Manhattan. Jed Rakoff is widely recognized as a legal thinker, a published writer, scholar, and independent-minded judge. Judge Rakoff reasons carefully, and he writes forcefully, and even when his decisions are overturned, as when he found the death penalty unconstitutional, his opinions are read, debated, and discussed. He is outspoken, he is courageous, and he is somewhat of a maverick, a word that is often used. Whether his opinions consider the likelihood that the innocent will be condemned to death, the application of copyright laws to the internet and MP3 file sharing, corporate fraud, Guantánamo detentions, Judge Rakoff writes with keen attention to principles, ethics, and social justice. At Columbia, Judge Rakoff teaches courses on white-collar crime, on science and the courts, and the interrelationship of criminal and civil litigation. He has served recently on the governance board of the MacArthur Foundation Initiative on Law and Neuroscience, and I think that prompted some of the concerns we'll hear about today. When we discussed topics for today, it was this last issue, the relationship of law and neuroscience, that Judge Rakoff mentioned as something he would like to talk about. He didn't think it would be terribly exciting to Swarthmore students, but I think otherwise. So your presence here certainly attests to that. I think it will be an excellent and provocative issue for Swarthmore students. And so the Constitution Day event for 2011, sponsored by the President's Office and the Department of Political Science, will be on how my neurons made me do it, how neuroscience is challenging the law's view of criminal and moral responsibility. Welcome, Judge Rakoff.
Well, I am really flattered by that very kind introduction. I'm very grateful that my wife is not here because she would demand rebuttal time. It is thrilling to be back at Swarthmore College. I love it almost as much as I love Article 3 of the Constitution, which is the article that gives me lifetime tenure. But I have to tell you at the outset, because we're going to open up for questions, I hope, fairly soon. I'm much more interested in hearing your views some ways than mentioning my own. But I have to mention that under the federal canons of ethics, I'm precluded not only from commenting on any ongoing case, not just my own cases, but any case, but also from commenting on any issue that might foreseeably come before me in the reasonably foreseeable future. So that concludes my remarks. Thank you very much. I want to talk about the impact it's already beginning to occur of neuroscience on the law, and particularly on the criminal law, and particularly on notions of criminal responsibility. And as Carol mentioned, I got sort of into this because I was on the governing board of the MacArthur Foundation Initiative on Law and Neuroscience. They figured an English major for sure was someone they needed on a scientific project, so they picked me. But it's been, for me at least, extremely mind-opening, and I'd like to share with you some of the thoughts that I've had as a result of what I've learned in that project. And I'm going to sort of assume that most folks here don't know that much about the law and don't know that much about neuroscience. So if some of this, for some of you, is too basic, my apologies in advance. The notion of criminal responsibility in the law is very simple and very well established, at least in Anglo-American law. It was basically codified by Blackstone, the famous English legal scholar, in 1776, a good year. He said that for there to be criminal liability, criminal responsibility, there has to be both an evil act, an actus rea for you Latin scholars, and an evil intent, a mens rea. With slightly different wording, that's still the law of the United States today, and relevantly for today's purposes, it's now constitutionally required. In a quite famous case some decades ago called Morissetti, the Supreme Court said that absent a clear indication from Congress that it wanted strict liability or something else of that sort, it will be constitutionally presumed that for there to be criminal liability and criminal punishment, there must be an unlawful act and an unlawful intent. And the intent basically is knowing that you're doing something wrong and intending to do it. If you look at a typical indictment, it says John Doe is charged with committing this crime unlawfully, knowingly, and willfully. And unlawfully means that his conduct violated the law. Knowingly means that he wasn't sleepwalking or completely unaware of what he was physically doing. And willfully, the most important term, really goes back to the medieval concept of free will. He intended to do what he did. He may not have known it violated the law. Ignorance of the law is no defense. But he intended to do the antisocial act that he then carried out. It's a very simplistic psychology if you think about it, not in legal terms, but in psychological terms. It is very unnuanced. You might wonder about things like insanity defenses, duress. Those are very narrow. They're recognized by the law as so-called affirmative defenses, but they are extremely narrow. The insanity defense in most jurisdictions in the United States is limited to people who literally did not know the difference between right and wrong. The duress defense is limited to people who literally have guns to their heads that forces them to do the antisocial act. By and large, the more nuanced issues, whether the person had diminished capacity, whether the person had a tough upbringing, whether the person suffered from some malady, is taken account of in sentencing, where the rules of evidence are very relaxed, but is not a defense to liability, to responsibility itself. So that's the law. So to look at neuroscience, and by neuroscience I basically mean the developing science of how the brain, how the physical movements of the brain affect what we think. It's more narrowly usually called cognitive neuroscience. But let's take some typical examples. The two examples I'm going to give are very, very well known to neuroscientists, but hopefully not so well known to you, so I'll trot them out. The first involves a fella known in the literature as Alex Lanu, L-N-U for last name unknown. And the reason his last name is unknown is because in the reported case, for privacy reasons, his name was not disclosed, but it's a real case. And occurred about 10 years ago. And Mr. Lanu was a perfectly respectable businessman. He had a no criminal record. He was considered a model citizen. He was a loving spouse and father. And shortly after he turned 40, he began getting interested in child porn. And pretty soon he got obsessed with child porn. And soon after that, he began making inappropriate remarks to his 10-year-old stepdaughter, and finally he molested his stepdaughter, and he was arrested. And he immediately pled guilty. And by the way, in most jurisdictions, this offense carries very heavy penalties. He said he knew what he was doing. He knew that it was wrong, and he couldn't quite explain why he did it, but he had no defense under the law to liability under the notions of criminal responsibility that I just mentioned earlier. Well, the judge was a little nonplussed by the fact that this fellow had been such a good citizen till only like a year or so before. So he said, let's send him off to treatment. Now, this was a little bit of a finagle because there is no known effective treatment for people who are obsessed with child pornography. I wish there were, but there's not. Nevertheless, in this cold, cruel world of ours, there are people who make a buck by saying they have a treatment, and the federal government and many state governments typically invest lots of money with these folks. So he was sent off for treatment, and he flunked. He got worse. He seemed to understand what the folks, this was mostly cognitive therapy, what they were urging him to do, but he didn't do it. And finally, the treatment center said to the judge, this is a hopeless case. You better go ahead and sentence him to prison. So he was brought back for resentencing. The night before his resentencing, he experienced very severe headaches, and he was taken to a hospital, and they gave him an MRI, and it turned out that he had a very large tumor impinging on the amygdala, which is the part of the brain that, among other things, tends to exercise as a restraint or send out signals that exercise a restraint on impulsive behavior. They weren't concerned with that. What they were concerned with is that this was a fast-growing tumor and was life-threatening, so they took out the tumor on an emergency basis. And as soon as they did that, he ceased to be interested in child porn. He ceased to have any desire to say inappropriate things or molest anyone, and he returned to his previous positive state. The judge was informed of all this and said, this is terrific. It shows that he wasn't to blame, he wasn't at fault. Words that I'll come back to in a little while. And so I'm going to release him on probation. About a year later, this gentleman began showing signs of interest in child porn. And this time they didn't wait. They took him right into the hospital, and they saw that they had missed one small part of the tumor, which had now grown and was beginning again to impinge on the amygdala. And they took it right out, and he went back to being a law-abiding citizen and has remained so, as far as I know, ever since. One question I would put, and I'm going to, in this little talk, put a lot of questions and give very few answers. But one question I would put is, what if that second tumor had been inoperable? What if they knew that the tumor, or had every reason to believe at least, that the tumor was causing this behavior, but they couldn't remove the tumor, in my hypothetical, because there would be too many risks to him? What should society have then done with this gentleman? Should they have locked him up, even though it wasn't, quote, his fault? Should they send him off to treatment when it really was acknowledged there was no treatment? Should they have let him lead his life, which almost certainly would have led to some terrible incidents of molestation of children? What do you do with a case like that? Fortunately, they were able to remove the second tumor. But that brings me to my second case, which is a case that some of you, I am unfortunately old enough to remember, which is the Charles Whitman case. So this is 1966, I was a student frolicking at Swarthmore College. Well, maybe not frolicking, wishing I were frolicking. Charles Whitman grew up in Texas. He was an Eagle Scout. He was an excellent student. He went to the University of Texas, and he began to have violent thoughts that he couldn't quite explain to himself. He was concerned about them, didn't really do anything about them, except he did make it known to some folks that he was concerned about it. And one day he climbed the tower in Austin at the University of Texas with a shotgun, and he shot 13 people dead, shooting down from the tower at whoever randomly was walking by. The police came and they shot him dead because he wouldn't surrender. And his body was then taken to a medical examiner. And the medical examiner, this was before MRIs and CAT scans and PET scans, which are the instruments that have enabled neuroscience to make such advances. But this was at an earlier time. The medical examiner just opened up his head, took out the brain, and there was a tumor impinging on the amygdala. Now, no one can say for sure that that's what caused his erratic behavior. There's a lot of neuroscientific literature that says that it's likely that's what caused his behavior. But to put another difficult question, supposing he had not been shot dead, supposing they had discovered the tumor, supposing they had taken the tumor out, and a week later Mr. Whitman was perfectly normal and not going to harm a fly. What about those 13 murders? Should nothing happen? If we seriously apply the criminal notion of responsibility, he wasn't really responsible in the sense of voluntarily choosing, in a free will sense, to do those murders, although in a much more superficial sense, he knew what he was doing. He wasn't sleepwalking. Should, in my hypothetical, after the tumor was removed, should we lock him up? Should we not lock him up? What do we do with a case like that? So, neuroscience, which basically grew out of the development, as so many sciences do, of new instruments, is finding more and more and more cases, usually more subtle than what I've just described in those two cases, where it can be said with some reasonable degree of certainty that actions and thoughts that people are having are not voluntary, at least not voluntary in the sense that the legal system posits as its model for criminal responsibility. Basically, why neuroscience is able to do that is that we can now see the brain as it operates. That's really what's going on. It's seen somewhat indirectly. Those of you who are into neuroscience will know that you're not actually seeing the neurons fire. What you're seeing is the blood that's associated with the firing of the neurons, and the blood contains iron, and an MRI is basically a huge magnet that picks up magnetic movements of the blood. I'm grossly oversimplifying now. But you can see what's going on in the brain in a way that we never could even 20 years ago. And we're seeing a lot of things that are giving us pause. Now you may say, well, this is not totally new to the legal system. We've dealt for years, if not centuries, with people who get drunk and do something that they wouldn't do while they were sober, or people who take drugs and get high and do things they wouldn't do when they were sober. But the traditional view of the legal system is that there's an element of responsibility there. You chose to get drunk. You chose, at least in the first instance, to use those drugs. Alcoholism and addiction complicate that picture tremendously, and I want to come back to that as well. But there's an element, albeit a reduced element, of voluntariness in those situations. There's no voluntariness at all in the case of Mr. Lanoux and Mr. Whitman. They didn't choose to have a tumor. They didn't choose to have their behavior change in any respect, but it happened. So how's the legal system going to deal with that kind of situation, and does it cast some doubt on the model that we've had for at least 200 years or more when it comes to criminal responsibility? Now, before I hark back to that big question, let me mention the ways in which neuroscience is already affecting the legal system, because I think they're illustrative of, if you will, both the promises and the threats that neuroscience poses for the legal system. There are basically 5 or 6 ways in which neuroscience is already impacting the legal system. One is you now often see at sentencing a defense lawyer will raise some abnormality in the defendant's brain and say, Judge, I can't show, neuroscience isn't at the point where I can show that this abnormality definitely caused this aberrant behavior, but it might well have been a factor. We urge you to take that account. You might say, what does it matter? He still did what he did, but it actually is something that judges often take account of in the same way they take account of sociological data about the defendant grew up in a poor family or in a crime-ridden area, or psychological data. He had terrible parents who brutalized him, or things like that, stuff that comes out of sociology and psychology. There is this potential difference, but it's not there yet, that the neuroscience is much harder science. It's much more testable in a way that, with no denigration of sociologists and psychologists, their stuff cannot really be tested because there are too many variables in the way that neuroscience can be tested. But the other side of the coin is neuroscience is just getting started. Most neuroscience data is still group data, not individualized data. Even there, though, it has a little bit of impact on responsibility. And an example of that is what we now know about adolescent brains. There's a lot of data that tells us what every parent already knew, which is that teenagers are impulsive. But what it shows is that the reason for that is that the part of the brain, again, the amygdala, that is wired into the parts of the brain that respond to impulses or desires for impulsive behavior, that the connections between those two parts of the brain, while never totally absent, develop much more fully in the late teenage, early 20 years. And until they develop, there's a tendency not to think twice, so to speak, before you take impulsive action. And that finding was cited by the Supreme Court of the United States in a famous case a few years ago, where they held that the death penalty cannot constitutionally be applied to adolescents. Now, it wasn't the ground, the so-called holding of that decision. The holding of that decision, which was something of a fudge, was that there had been a consensus that had developed that you shouldn't put adolescents to death. But really, and I agree, is such a consensus. The reason is, why is there such a consensus? And it's because I think we already understand that adolescents don't have the same controls, cognitive controls, that adults do. In my view, it will only be a few years before you will be able to do an MRI of an adolescent defendant and tell how much cognitive circuitry has been developed between the amygdala and other parts of the brain. And that, for better or worse, could be helpful in a determination that's made by prosecutors all the time, which is whether to charge an adolescent as an adult. Right now, it's pretty much the unfettered discretion of the prosecutor. This teenager went out and killed a lot of people. The public is demanding his head. We're going to charge him as an adult. This teenager just did something, committed a robbery. It wasn't. There was some threat of violence involved, but there wasn't much violence. There's no one in the press is following this case. We'll charge him as an adolescent. That's the kind of decisions that are being made now. This would at least give a more informed basis for making those kinds of decisions. Another area where neuroscience is beginning to get into the legal system is in prediction. It's part of every sentence for the judge to have to predict, will the guy do it again? It goes under the term specific deterrence. The focus is, what can I do as a judge to prevent him from doing it again? But implicit in that is making a prediction as to the likelihood he or she is going to do it again. Well, up to now, there's only been one good way of predicting with any degree of confidence whether a defendant is going to recidivate, as they say, and that is that he's a past recidivist. A lot of data shows that if he's done it 2 or 3 times before, he's going to do it again. But, of course, in a huge number of cases, there is no such data because it's a first-time offender or maybe just second time. And we don't have very good ways of predicting whether he's going to do it again. Neuroscience is beginning to look at this in one special group because, again, neuroscience data is largely group data at this stage. But it's a very interesting group. It's the group of psychopaths. Now, psychopaths are less than 1% of the general population. They are 5% of the criminal population. They account for 40% of all violent crimes in the United States. They are notoriously unrehabilitable. And they exhibit personality traits that are so very different from other convicted defendants that you really wonder whether something different is going on in their brains. And there's now a major study, part of this MacArthur project, involving the prison population of New Mexico. They're all being given endless MRIs. Any of you ever had an MRI, you know it's no fun. It may be cruel and unusual punishment by itself, but they are actually all perfectly happy to do it. It hasn't been forced on anyone. And the initial findings indicate that there are a number of brain markers for psychopathy. Now, what are we going to do with that data if it proves to be really strong? And I suspect it may. So we'll now be able to identify, maybe at the age of 6 or 7, who is likely to be a psychopath. Do we lock the kid up because we know there's a high likelihood that he's going to commit a violent crime in the future? Do we do nothing then, but if he commits a violent crime, do we lock him up for twice the amount of time we would lock up anyone else because of this predictive capacity to show that he's a psychopath? Do we say, well, that's all group data, so we don't apply it at all to individuals, we just ignore it, perhaps at our peril? Do we say, oh, great, we can identify these folks at 5, so we will send them off for treatment, knowing there is no treatment? Maybe someday, hopefully there will be, but not yet. It poses these kinds of moral dilemmas that neuroscience is generating. A different kind of moral dilemma is the use of neuroscience to identify consciousness. This comes up, and this has happened already in the courts. You have a relative who has been in a terrible accident, and he or she appears to be now a vegetable kept alive by tubes, but there's no visible sign of any movement. The heart is still going. That's about it. And he or she is breathing. But otherwise, the person appears to be totally a vegetable. But is the person brain dead? Well, neuroscience is at the stage where they can determine that. And one of the ways they determine it, and determine not just whether there's activity in the brain, but conscious thinking in the brain, are some really nifty experiments where the subject lying there in this vegetative state is told by the experimenter, I'm going to ask you some questions, very basic questions about yourself. Is your birthday August 1st, 1943? That's my birthday, so it's a day that will live in infamy. Did you grow up in Philadelphia? So, very basic questions. And Mr. Subject lying there, if the answer is yes, think about food, because we know that will activate one part of your brain. And if the answer is no, think about arithmetic, because that will activate a different part of your brain. And in virtually every study that's been done of that sort, anyone who has the slightest cognitive ability left, and it turns out to be a very substantial portion of these folks, answers all those questions right. So now, think of the moral dilemma there. You were in agony whether to pull the plug. You were the guardian, you were the person who could apply to the court for permission. All of this varies tremendously from jurisdiction to jurisdiction as to who could do what, if anything. But it was your responsibility, and previously you were all set to do it because it looked like the person was, for all intents and purposes, dead. Now you know there's a thinking human being there, but a thinking human being who is trapped, and the doctors are telling you trapped forever, in his unmoving body, the ultimate imprisonment, if you will. What are you going to do? So these are, again, this one is more a problem. It's partly a problem for the law. It's partly a problem for the individuals who some jurisdictions give power to in these circumstances, but a very serious moral dilemma posed by neuroscience. Now, I want to mention just two others. There are something like 600 reported cases where neuroscience evidence has already come into the courts, and there are many, many different circumstances. I just want to mention two more, because these two, I think, point up both issues about criminal responsibility and also show that neuroscience can be misused as well as used helpfully. The first one, which is the case of the misuse, is so-called neuroscience lie detectors. Now, the legal system, as all of you recognize, is grounded ultimately on determining what the true facts were of any situation. There's no point applying the law unless you know what the facts were, and that is one difficult task. And so there's always been a desire for some instrument that would enable us to see whether witnesses were telling the truth. Even though they're telling the truth, they're often wrong because of memory failures and things like that. But at least if we could eliminate people from lying on the stand, and people have lots of motives, in many cases, civil and criminal, to lie on the stand, that would be a tremendous advance. The legal system primarily now relies on cross-examination. Cross-examination is a very good tool. No one pretends that it's infallible. Back in the late 1800s, there was developed not by scientists, a polygraph, the so-called lie detector, which is based on the theory that when you lie, your pulse rate increases, your sweat increases, your heart rate increases, and so forth. Certain common sense to that. The problem with that, of course, is that when you take a polygraph test, your heart rate and all those things also increase for 100 other reasons, like you're nervous, because whether or not you're going to get charged with a crime might depend on how well you do on this test. Innumerable studies have shown that there's a very, very high percentage of so-called false positives in the use of the polygraph. I want to digress here with if I may, for just 1 minute, to mention a case that came before me which involved a polygraph, but I think it shows the same dangers that exist in what I'm about to tell you about, which is the neuroscience lie detector. This was a case called Higazi. Right after, on the day of 9/11, everyone who was in the Millennium Hotel, which is a hotel right next to Ground Zero, was of course evacuated, and many of the guests left their stuff in the hotel. So about 3 months later, the police allowed the security guards from the hotel to come back to get the guests' belongings so they could return them to the guests. And one of the security guards then reported to the FBI that he had found in a room on the 50th floor, which is the next to highest floor of the Millennium Hotel, in one of those little wall safes that hotel rooms often have for personal belongings, a copy of the Koran, and a pilot's radio. A pilot's radio is a kind of radio used to guide planes from the ground. And the FBI immediately began to suspect that maybe whoever was in that room was an accomplice who was using the pilot's radio to guide the terrorist planes to the Twin Towers. They did a little more digging. They found that the room had been occupied by a guy named Abdullah Higazi, who was purportedly an exchange student. So what was he doing in a hotel room? And who previously had been a member of the Egyptian Air Force, and who had only entered the country about 2 weeks before 9/11. So all of that got their suspicions really aroused. So Mr. Higazi was by that time living in Brooklyn, where all New Yorkers eventually wind up. And so they went out to interview him, and he had explanations for everything except the pilot's radio. He said, I didn't have a pilot's radio. And of course the FBI had the word of the security guard, who had absolutely no motive to lie, and the security guard was certain that he had found these two things, the Koran and the pilot's radio, in the very room that Mr. Higazi, without question, had occupied. And Mr. Higazi kept saying, it wasn't my radio. So they arrested Mr. Higazi. They wanted to charge him with lying to the FBI. They knew it was kind of weak at that point. They brought him before me on something called a material witness warrant, which allows them to hold a person for investigation for a fairly modest period of time, no more than 10 days. I expressed on the record a good deal of skepticism about whether they had enough, but I allowed them to hold him for a few days, not the full 10, but 3. In my courtroom, Mr. Higazi is screaming, I want to go on a lie detector test. It's not my radio. I explained to him that this was polygraph evidence is not admissible in federal court, and the reason it's not admissible is there's so many false positives, so you don't really want to do this, was my implicit suggestion. But he said he did. And the FBI, of course, said, we'd be delighted. So they brought up, not on any order of the court, but at his volunteered request, and over the objections, I might add, of his own lawyer, they brought up, at Mr. Higazi's request, one of their top polygraph people from Washington. They sat Mr. Higazi down in a room. The lawyer was told by the polygraph expert that the lawyer had to leave the room because any interplay between the lawyer and the client could upset the delicate balance of this very scientific instrument. But he could be right outside, and if at any time Mr. Higazi wanted to talk to his lawyer, they would stop the music and let him go out. So they held him in there for 3 hours, but he never asked to go out, and they put him on the polygraph, and they asked him, did you have a pilot's radio? And he said no, and they, sure enough, the instrument showed that he was lying. And they asked that question. They asked a lot of other questions, but they kept coming back to that question, and each time the polygraph indicated that he was lying. Meantime, as this happens more and more, Mr. Higazi is getting ever more nervous, he's seeing, if you will, the door is closing behind him, so to speak. And finally he says, well, maybe it was my radio. At that point, the FBI agent stops the music, goes out to see. The lawyer says your client has just confessed to having previously lied to the FBI. We're going to charge him with that. Do you want him to give a written confession? The lawyer, to his very great honor, said, absolutely not. I don't know what went on there, but we're going right back before the court. So they come back before me, and now they're charging him criminally with lying to the FBI. And now, of course, they have probable cause, given his statement that well, maybe it was my radio. In my view, they were getting all set to build a case against Mr. Higazi as a co-conspirator for the 9/11 terrorist attacks, which would have been a capital offense. But God or good luck intervened. 3 days later, an American Airlines pilot went to the Millennium offices and said, you sent me back my clothes, you never sent me back my pilot's radio. And the whole thing then unraveled. The pilot had the radio on a totally different room on a totally different floor. The security guard was so incensed by 9/11 that he decided, I'm going to get anyone who's Muslim no matter what. And he had made up the story. Higazi had given a false confession under stress. That's another whole neuroscience area that I won't have time to get into today. And it could have been an unbelievable disaster. Instead, Mr. Higazi was released. The guard was criminally prosecuted. Mr. Higazi brought an action for a few $1 million against the government, which was eventually settled. I ordered an investigation because I was concerned whether the FBI was using the polygraph to simply say you're lying, even if the polygraph didn't show you're lying, as a device to try to get a confession. But at least what was reported back to me by the Inspector General's office was, no, the polygraph had shown he was lying. It was just a defective polygraph. Now, I give that very long-winded but perhaps interesting story because the neuroscience lie detector seems to me to have the same dangers and more. There have been studies, very elementary studies, that show that when you lie, your brain requires more activity than when you tell the truth. You have to think you're lying. In some ways, this is, I guess, a testament to free will. You really have to voluntarily choose to lie. So you can see the brain lighting up. And when I say lighting up, that's just the way the pictures look. It doesn't really happen. You can see in the neuroscience images the brain lighting up more when the guy lies than when he doesn't lie. But of course, it will also light up for 100 other reasons. And neuroscience isn't at the point yet where it can factor out those confounding factors. And so there are at least as many false positives in a neuroscience lie detector as there are in the polygraph. That has not stopped two companies from marketing the polygraph to police authorities. Favorite customers, of course, the CIA. One company, the one that has, if you will, the better academic credentials, including a full professor from the University of Pennsylvania right down the block, so to speak, is called Cephas. And the other has the giveaway name of No Lie MRI. But they have made repeated attempts to get their evidence accepted in the courts. And what have they done to do that? They have relied on the U.S. Constitution. They have said, under the Sixth Amendment, under both the Fifth Amendment due process and the Sixth Amendment various guarantees of a fair trial, even if this has, is not always right, it's certainly right at least maybe 50% of the time, we should be able to put it in. I don't think that the prosecutor shouldn't be able to put it in because he has to prove proof beyond a reasonable doubt. But all we have to do is show a reasonable doubt. So let us put it in. Now that has been rejected by the two courts that have considered it thus far, and I frankly don't want to comment because it might come before me someday and then I'd have to really say something about this absurd and ridiculous argument. But, nevertheless, someday there may be a court that will receive this evidence. And when it is received, it will, in my view, be much more powerful in its impact on the jury than the polygraph could ever be, let alone mere cross-examination, because it will come with all the bells and whistles of science. And that will have, I'm afraid, a very unfortunate effect on how the evidence is reviewed by a jury. The last area, the one that holds out in some ways the most promise, is in drug addiction. We've known for a while the basic mechanisms within the brain of how people become addicted to drugs. When you take a drug like heroin or cocaine the first time, it releases dopamine, which is a substance that causes you to feel tremendous pleasure. Typically on the first high, it will be 5 to 10 times the amount of dopamine released during sexual climax. So this is, what can I say, every adolescent male's dream. What happens then is, in relatively quick order, the body develops a certain tolerance, and it requires more and more of the drug to have that effect. And eventually you can't have that effect at all. It just takes massive doses of the drug to just feel normal. That's how addiction gets going. There's a genetic aspect to this as well that we know less about, but approximately 10 to 20% of the people are much more prone to addiction than the rest of us. So that's the basic mechanism, but all treatments for drug addiction, while they haven't been as hopeless as in the case of psychopaths, for example, or child porn, have a very low success rate. There are two types of treatments: chemical treatments like with methadone, psychological / behavioral treatments, getting people to out of the neighborhoods where everyone is dealing drugs, suggesting to them other ways to think when they feel a craving and so forth. The data is not so easy to come by because there's billions of dollars invested by the governments in these treatment programs, and they all like to hype their success rate. I'm just waiting for the day when there's a U.S. News and World Report survey of how good they are, and then the hyping will become really extreme. All the serious studies indicate maybe a 40% success rate at best. By success, I mean that once the person goes off the chemical, like methadone, or leaves the treatment facility, he or she within 1 year reverts to using the drug. That's the standard usually used in this area for testing whether it's successful or not. And it's a pretty low rate, especially given the very huge amount of money invested in this stuff and the goodwill of, I don't mean to suggest these folks are charlatans. I think many of these programs are run by people with very goodwill who are themselves mystified why they're not doing better. So here's what neuroscience says is the reason. When you get that first high, it creates a very vivid memory in your brain. And the memory is not unlike what happens with Pavlov's dogs. Cues, a whole host of cues, will re-trigger that memory, so that you may be completely drug-free for 2 years, and then you go to a party, and it's the kind of party that triggers this memory, and you start using the drug again. It's a conditioned response. Now, what does that mean? Well, someday, and maybe not so far off, we may actually have drugs that remove specific memories. But before we get to that, memories do fade. The initial data, a lot of this is still in progress, the initial data indicates that it takes 10 to 20 years for these kinds of memories to fade, the memory from the first high. And so we are confronted once again with a dilemma. If we really want to cure someone of drug addiction, we would have them undergo inpatient treatment for 10 to 20 years. That's like locking them up for 10 to 20 years. Do we really want to do that? Even if we wanted to do that, if you will, ethically, and even if we overcame the constitutional problems to doing that, the cost of that would be vast. So there are a lot of problems with that. I do want to allude also to the fact, I mentioned the constitutional aspects. A lot of this stuff raises serious constitutional questions. Take the lie detector, the neuroscience lie detector. Can you impose that on someone? Is it on a criminal defendant? Is it a violation of their Fourth Amendment right against search and seizure? Is it a violation of their Fifth Amendment right against self-incrimination? Is it a violation of due process, and so on down the road? Those are all unanswered questions. It hasn't gotten yet to that stage, but it's coming. So to try to draw all this finally together, and then, as I say, I'm very interested in hearing what you folks have to say. We have a legal system that, in terms of criminal responsibility, posits a very simple free will type of psychology. I did a bad act. I knew consciously I was taking this act, I knew it was wrong in a sense of disapproved by society, though I may not have known the specific law it violated. And that's it. Anyone who fits that pattern gets criminally convicted. Neuroscience suggests that there are immense numbers of situations where that pattern breaks down. Not totally breaks down. The tumor situation is really an extreme. More often it's, yes, I still have some voluntary control, but it's not as great as it seems to me. It's not as great as it seems to you. It's colored by all these operations of the brain, physical operations that may have no more rhyme and reason than that a particular circuitry was not connected or a particular neuron did not fire properly. How do we deal with that? We might deal with it in the worst possible way by saying, forget about the state of people's minds altogether. Just look at their conduct. They did a bad thing, lock them up. I don't think there are many folks, and there's certainly no judge I know of who thinks that's the right approach. But finding a new paradigm to adjust to these nuances, more than nuances really, these revelations of neuroscience is something that we have just barely begun to grapple with. So those are my thoughts, and I thank you so much for hearing me out.